Welcome to Ask the Attorney, brought to you by Stephen Kelly Law.
Well, hi, everybody, and thanks for joining us this evening for another edition of Ask the Attorney. I'm Renee Charles, your host, alongside attorney Stephen Kelly, and thanks for being with us again.
Thank you for having me.
And by the way, Stephen Kelly, you've got 3 offices, Springfield, Princeton, and right here in Peoria on Knoxville Avenue. And if people want to give us a call to ask your questions, the number is 681-1900. They can call, leave a message with your office, and you'll get back with them to answer the question.
As soon as I can, yes.
All right. Well, our topic today is a very timely subject. We actually talked about this several months ago, but as COVID-19 continues to unfold, things are constantly changing.
Yep. Last time we talked about it, it wasn't even a law yet.
Right.
And in June of 2020, the legislature made a new law. And the law had talked about COVID and the workers out there in the state of Illinois. And what the legislature did is they made a presumption. They made a presumption for certain classified workers to, if you contract the virus of COVID-19 while working and you fall within this classification, it's presumed to be work-related.
So this is kind of a workers' compensation, but it's a different title, but it's very similar to getting injured on the job, where in this case, certain classifications of employees will be presumed that they contracted COVID-19 on the job.
Yeah, technically it falls under what they call the Occupational Disease Act. It's the same thing as the Workers' Compensation Act. So basically the legislature said since it's an occupational disease and it's a disease or a virus that we can't see, touch, or know when we get, they created this presumption for certain workers saying that if you get it and you're working under these classifications, it could be presumed to be work-related.
So explain the presumption. What does presumption mean?
Well, the presumption is, if you look at the scales behind us, or you talk about attorneys presenting the case, we have to prove our case. Mm-hmm. And in the Illinois workers' compensation system, we have to prove our case, if you're proceeding with the case, by 51%. So it's they call that by preponderance of the evidence. So you have to prove your case by 51%. This presumption comes in, and it's a factor that the judge or the arbitrator looks at, and they give you an additional weight, or you come in with the assumption or presumption that it's work-related right off the bat.
And so that obviously is going to tip the scale in your favor, but it doesn't mean that your case is a case.
I get many phone calls from a lot of individuals and clients saying, hey, I fall within this classification as a worker. I get the presumption. That means I should get benefits right away. I win my case. That's not what the presumption is. The presumption allows you to start ahead of the case, or it's presumed it's work-related. And there are factors that come in, and we'll talk about later, that could affect that presumption or take it away from you. But it's important with this type of virus that we can't see and touch that the legislature is saying, hey, look, you have a case, and you can start the process.
So you still have to prove it. So things like, as we were preparing for this, you used the example of, I went to a wedding, and everyone there ended up with COVID-19.
Yeah,
that's going to work against you because you can't say that it may have come from work.
Exactly, and that's what the arbitrator and the judge are going to look at, and you have to evaluate. Attorneys evaluate. Mm-hmm. When a client comes in, those are questions I ask clients. Where were you? Have you been to what they call a super spreader event, weddings, or have you been to a church where other members have gotten it? And if those questions and you answer yes, that could affect this presumption. And if the answers are yes, you have other contacts out there away from work, it could take away the presumption.
Gotcha.
And if that presumption's taken away, then you're just starting out equally with the employer, and you got to prove your case.
So what's the time frame for this? Obviously this pandemic started earlier in the year, or last year even. So is there a time frame that your diagnosis as a positive case has to come within?
Well, it's a great question because it's so tricky now with COVID-19. You could have symptoms, you get the test, and then you're told 7 days later you have the diagnosis. Yeah. So it's a loose window. Okay. You have time to pick a date of accident. The legislature doesn't require you to pick a certain day. If you have the positive test, you have the diagnosis, then you could have a claim if it's deemed to be work-related. You could prove it's work-related.
So in this case, because this is still unfolding, and this is, we've used this word so many times, unprecedented, that there is a little leeway in the law to assist.
Absolutely, and it's such a unprecedented event for the legislature. They even gave a time frame for this this act, and they said, look, if you contract COVID-19 in March of 2019, up to the end of December 2020, then you have that presumption. Now, I don't think the legislature meant to just shut it off at the end of 2020.
Well, yeah, that's a good question there.
I think what happened was they didn't know if there would be around or not. They didn't know if we would have a vaccine by then. But so they put a time frame on December 2020, and by doing that, I think we can expect them to extend that as this progresses.
Especially because we're hitting such an apex right now, and cases are increasing around the globe. We don't know what's going to happen next. So even though it says this law runs through December 31st, you're expecting it to be extended. And
I do expect to be extended because of what we're going through now. And it's going to take a while to get the vaccine to the certain workers and then to the general public. So I think if you have the diagnosis of COVID-19, even beyond the year January 1st, 2021, this presumption is going to apply to you if you fall within the classifications.
So let's say, for example, you don't necessarily have a positive, I'm not positive myself, but I'm forced to quarantine, which means I can't go to work. And if you're a frontline worker, you're a first responder, you're an essential worker, in some of those cases, if you're quarantined, you're not going to get paid. Does this come into play there?
That's a great question. And with this new act and all the uncertainties that we have, I can't give you a yes or no answer. But in dealing with this, and I have clients who are firefighters, clients who are police officers, AMTs, this question comes up because they're forced to quarantine because a fellow member may have had, they were in contact with them. And those questions are posed to me, and the answer to my answer is yes. If your employer forces you to quarantine because you had a contact at work, and you're forced to sit at home for 14 days and miss pay, it's my opinion that you'd be entitled to workers' compensation benefits because the employment you had to quarantine.
So that's a case that you would consider taking?
I would consider taking. In my practice, I have a special heart for firefighters, police officers, first responders, and I think they're the ones, really, this is what the law was provided for. They're put in emergency situations. They're put in situations where they may not be able to protect themselves. And they're there to serve the public. And I think this law, that was one of the main reasons why the legislature enacted this presumption.
So what kind of benefits might someone be eligible for in this case?
Great question, in the sense that it's the same benefits in any workers' compensation case. So if you miss time from work, you'd be entitled to off-work benefits, quarantining, or you're sick yourself, you have to stay away. Also, medical expenses. Now, right now, we're uncertain how extensive the medical bills are going to be. If you're asymptomatic or if you have just a minor cold symptoms, certainly those bills be paid for. The bills would be taken care of by the employer if it's work-related. The last aspect or benefits you may be entitled to is a permanency effect. What is your disability? What long-term effect did you have from having COVID-19? That's a really uncertain area right now.
Yeah, we don't know that right now.
We don't know that right now. And if you have an attorney, if you hire our office, we're going to protect that for you because the studies show, what we know now, is that you could have a long-term effect on your cardiac system, on your pulmonary system. Even though your symptoms are done, we don't know what COVID-19 is going to do to the body.
We don't know what's going on yet.
Right, we don't.
Talk to me about rebuttable presumption. So this law creates rebuttable presumption. Yep. What does that mean? Well,
you can have a non-rebuttable presumption or rebuttable presumption, and certainly just what it says. That means an employer has a right to refute this presumption. If an employer can bring up certain facts, the way the law is written right now is this presumption could disappear, and you don't have it when you start your claim.
So if I'm the employer, I want to find a way to refute this claim if it's possible. So again, just because you have the presumption doesn't mean you get the claim.
Correct. Just because you have the presumption doesn't mean you win.
Okay.
You get the presumption, you're given a head start, or it's an extra weight to put in your side of the case. But if that presumption's taken away, you have to prove your case just like any other case you present to the Workers' Compensation Commission.
I think that gives us a good place to take a quick break. When we come back, I want to talk more about what you have to prove, that burden of proof, and who this really impacts. So we'll take a break, and when we come back, we'll continue talking with Stephen Kelly about COVID-19 as a workplace injury. So stay with us. And we're back with Ask the Attorney. Stephen Kelly, attorney, here with us. I'm Renee Charles. Thanks for tuning in. If you have questions for Stephen here, you can give us a call at 681-1900 and leave a message, and then your office will get back to them soon. We're talking about COVID-19 as a workplace injury. So with this law, which we kind of established in our first segment here, that it became a law in June, it gives a presumption to those specific classes of workers that if they receive or a positive test for COVID-19, that it will be presumed that it came from work.
Correct.
Who are these people? What are these jobs?
The obvious ones we talked about earlier, we've talked about in the past, are the police officers,
Right.
the firefighters, EMTs, paramedics. But it also falls down to individuals as correctional officers fall within this category. In addition to that, healthcare providers.
Right.
If you're taking care of individuals at a hospital, it could be presumed, since you're the healthcare provider, you do get this presumption. The legislature's given it to you. And strangely enough, there's essential workers out there, aside from the first responders, that also are given this presumption. You know, if you work at a local grocery store and you're required to be there, certainly you're entitled to this presumption. You know, we know as this virus has progressed from 2019, things have changed. You know, we used to go to the grocery store, in 2019. They didn't have the plexiglass.
Yeah.
Things have changed. We've evolved. We've kind of learned with the help of the CDC of how to combat this. And so the legislature's handing that presumption not only to first responders, but people who are out in the public.
And you're absolutely right that if you think about when this really came into full swing, we thought, okay, wear a mask and protect yourself. But now we do have all these different changes, and we don't know what other changes are going to come along. So right now, these categories of employees are the ones that we're really focused on because they've been out there more exposed than most other people.
The common cases I have, people come in here, they fell in a hole. They fall off a ladder. They know when they got hurt.
Yeah.
They can identify it. An x-ray shows you a broken bone.
Sure.
We cannot tell right now if you contract COVID-19. We don't know when it occurred. We can't pinpoint it. And that's what this presumption does. It kind of eases the burden upon a claimant to say, hey, look, we know you have this type of job, and we know you're out there exposed to it because of this job. And we know there's situations that it's uncomfortable or maybe exposing you. Since you do that, this is what we're going to give back to you since you're giving us. It's a presumption.
Is this only in Illinois?
Well, as of right now, other states are adopting it, but Illinois is the one I think has been a leader on it. As we all know, Illinois has been fairly aggressive with the restrictions in addressing COVID. And certainly it is definitely a help to these employees in Illinois.
Now, when you talk about essential employees, I see it as two classifications. So, for example, where I work, we have people who are considered essential and we need them to be on campus, and others that can work remotely. But that's not necessarily the category we're talking about. We're talking about essential from a grander scheme.
Absolutely. We're talking about essential employees that help us live. We have to eat. Grocery store workers, we have to survive. So those are workers that are out in the workforce to help us live our essential and get our essential needs to live.
Can you help someone determine if they're an essential worker or not? Like I said, at my place of business is different than someone else's, and somebody who is working on grounds and keeping the grounds and the buildings and the facilities going, they're essential to our operation, but they're not essential to societal operation.
At some point, an arbitrator or judge are going to have to decide that. What does essential mean? When a statute like this is enacted, they give you definitions. This is an essential employee. And that's why we have lawyers. There's these lawsuits. Do you fall within that classification? So certainly, you have to get this presumption. If you come in and sign up with a lawyer, you sign up with my office, you have to fall within this classification to get this presumption. So our job is to make sure you fall within that classification. And we talk to you. We listen to what type of work you do, and we will let you know whether or not you fall within this essential work classification to get the presumption.
All right, so we've identified who's part of this. We've identified what it is. But a little while ago, we talked about you have to still prove that this came through work. What's the burden of proof, and how difficult is it to prove this, or how easy?
Yep, it's going to be tough. I think there's going to be a lot of municipalities are going to fight this. I think they're going to say we're not just going to pay for a COVID-19 diagnosis. First of all, you have to have the diagnosis, or at least suspected to have the diagnosis. That starts to claim. Then you also fall within this classification. You get the presumption. But certainly you're going to be asked questions by your employer or an insurance adjuster, and those questions are going to be asked of you just as you asked me earlier. Hey, were you at a wedding? Do you have other family members who have contracted this virus? I've had clients come in who've had college students who went to school to begin the year, The student came back, was positive, and then that client tested positive after that. That creates a little bit of a confusion where you got it, and an employer is going to ask you those questions, and if the answer is, I had contact outside of work, that's going to take that presumption away, and you're going to have to prove your case without that presumption.
Okay. What if family members have it, and maybe it's a smaller business type of a thing? How does that work if it's, again, not that essential person, but if you get it and say it's a small family business, how does that play into it?
Well, it's going to be an investigation of the facts, meaning if you're trying to determine whether or not you got it from the family business, the same questions as, who had it, when did they have it, did clients come in, how did you address customers coming into that business? And you're going to track the time frame of who got the virus and who didn't, and what your role was with that employer.
So when you know the burden of proof, when you've got that information, is that how you figure out what you're entitled to if this claim goes?
One of the things, I want to go back and talk about the burden of proof, it may be important in your case to get a doctor to back you up, to say, yes, that activity is a type that could have exposed you to it, or you have COVID and it's related to your work activities. But certainly the benefits we talked about, you're entitled to the benefits that any other injured person would be.
Okay. Got it. I want to do a couple quick questions. We had these come in beforehand, and then we're going to take a break here. I'm a police officer. I contracted COVID-19. Does this law mean I'll receive workers' comp?
Well, it means
sort of.
It means you get the presumption.
Okay.
So to start the case, you have that presumption, and the response of your employer is they have to say it's work related. So they should start the process of working with you to get the benefits. Now, through the process, if they decide or they think there's facts out there to take away that presumption, they may come forward. My experience and what I'm kind of feeling from the cases that are coming in is employers are denying it right away.
Yeah.
And you have to act, and you need help with an attorney to get that taken care of.
Because some of these cases, you need it to go right away.
Yeah, workers' compensation is a fast system, and you come in because you're not getting your bills paid, you're not getting paid while you're off work, and you're supporting your family. So you need to get this taken care of sooner than later.
Okay, we're going to take a break. When we come back, we have a few more questions that we've got from early on, and then we're going to talk also about the employer and what they have to prove and how that could also affect your claim. So stay with us. We're back with Ask the Attorney. I'm Renee Charles alongside Stephen Kelly. If you have questions for us, you can give us a call at 681-1900. Stephen's office will give you a call back with the answers as soon as we can get to them. I want to keep moving forward. We're talking about COVID-19 as a workplace injury. And I want to hit one thing that we touched on early before we fall into what the employer needs to do. We talked about medical bills. So obviously, if you're filing this type of a claim, you're hoping to receive some sort of payback, mostly for medical, especially with COVID-19. But we don't know what this virus can do to you in the future. And so how does that work?
It's so important to keep your medical rights and your concerns for medical future care open. And when you have a case like this, until we get a grasp on where this virus ends up, until we get a grasp of what it does to a body itself, you should keep that open if you think that you want to keep it open. I've had some clients say, I'm good, don't worry about it. But I've had other clients, especially those who are younger clients, they have 10 to 15 years of work. And without knowing the answers of what effect this has on the organs,
you don't know what the long-term effect is going to be. So if you close it now, you can't come back.
And you have a right to keep that open. You have a right to keep that open, and you don't have to close that out if you settle your case.
So what do employers need to prove? I'm kind of switching it around from what does the employee have to prove to what does the employer have to prove to not have this case? So
an employer has the ability to take this presumption away, which means the case doesn't go away, but just means that the presumption's taken away and you still have to prove your case. And what the legislature did was they put 3 examples of items or facts that the employer can bring to the table and say the presumption should be taken away. And one of those facts is if you hadn't worked at the office for 14 days. With the age that we're in now and what's this remote work activity, there's employees who don't even work at the office anymore.
Sure.
And the legislature said if you're not at work for a 14-day period consecutively, if that's the fact in your case, the presumption goes away. So you're going to have to prove your case that your COVID's related to your work without that presumption. That was
You don't get that head start. You don't get the scale tipped in your favor.
You
in
don't.
That case.
The gun goes off and you start the race at the same time.
Then the next one we have here is that the employee was exposed to COVID by an alternate source. This kind of goes back to, where have you been in the past few weeks? Have you been going, out to do things? Have you been at a wedding? Has somebody else in your family received
I think
positive?
One of the toughest areas going to be for lawyers and injured people is determining if multifamily members test positive. Because what happens is you don't know where they got it, who got it first, who gave it to who.
Yeah.
And certainly that's going to be an area that the employers and employees are going to be litigating for a long time.
Sure.
But if you track your diagnosis, you track the positive test, and obviously if you're the first one in your family unit who had it, then and that was from work, you would be able to prove your case.
And another piece of this that kind of works, I don't say against the employee, but is in the employer's favor, is if they're following CDC requirements and they're doing everything that is suggested by the CDC, that kind of works against the employee who may have contracted this or trying to prove they contracted it there.
If an employer can come forward and show that they were complying with the CDC requirements, that could take away this presumption. Once again, I think it's going to be a litigated area because then it's a fact question. Were they really following the requirements? How well were they following the requirements? Were they providing the protective devices? And I think this is going to create a lot of litigations, whether or not the employer can take this presumption away.
So you do need to be careful with this because as you're saying, well, my employer didn't follow all the guidelines. Maybe they did, but you didn't follow the guidelines while you were there, and that could backfire against you.
Well, in workers' compensation, fault's not a question. So if you're at work and you're exposed, it could be presumed to be work-related. It's these situations, this last exception or employers taking the presumption away, in my opinion, is more for those people working at a grocery store, working in a structure, as opposed to the first responders who are out in the community. I don't think that this exception applies because those emergency situations are unpredictable, that you don't know what you're getting into, and you can't protect yourself like you could if you were in a structured building.
So this law to me sounds pretty straightforward. I mean, as straightforward as we can be in this crazy time that we're in. Do you need, or what are the benefits of having an attorney if you're looking at filing a claim for this?
Just establishing the claim. This is something that the employers are not just going to roll over and pay on. And if you give the wrong information or you don't establish the right facts, you're not going to be compensated under the workers' compensation system. It's so important to be organized, and it's so important to have the facts with this presumption. And if you're one of these protected classes, you should be able to establish a work-related condition.
I want to bring a few more questions too. We've got a handful of them here. If my employer makes me quarantine due to a contact issue, am I entitled to workers' comp benefits?
We talked about that earlier in the sense that the employer is forcing you because of a work situation and you're quarantining, even though you have no symptoms, you've never been tested positive, it's my opinion they may owe you work comp benefits.
If it's a requirement for that you quarantine and your employer says yes you have to, then you could have the claim.
I know in certain municipalities, firefighters stay in the same building 24 on. If a couple of members get the virus and they tell others to go home and quarantine, yes, I think they'd be entitled to it.
So do I have to have the positive diagnosis, or can I have, again, the quarantine and I've got the symptoms?
The majority of the cases, 90% of them is going to be you have to have the diagnosis. But certainly the fallback situation, if you're forced to quarantine because you're contacted with someone, then you could also be entitled.
I like this one. I work from home. I had COVID-19. Do I get workers' compensation?
My knee-jerk reaction answer is no. However, certainly if you're forced to work at home and go out and you were exposed, but I got a feeling the employer is going to come forward and say, you hadn't been at work for 14 days, the presumption's taken away, and now you have to show that you got it somehow related to work.
And then recapping this one, which we've talked about a little bit before, if I get COVID-19, what benefits do I receive? There's not really a basic, this is what you get. It's going to be different for everyone.
It is, and the cases that I handle, there's a lot of exposure for off-work benefits. There's a lot of exposure for medical bills. This COVID-19, the majority of the cases that have come in are not those right now, but it's that future medical. It's that future concern about what this disease and virus has done to your body is what you need to be concerned about. And if you're concerned about it, you need to make sure you get an attorney and make sure you protect that right.
All right, well, we are running out of time, so I want to remind everyone, Stephen Kelly, attorney, you have offices on Knoxville Avenue in Peoria, also in Springfield and in Princeton. And if people want to give you a call, the phone number is 681-1900. If there's nobody here to answer right now, then you can leave a message and your office will get back to them.
We will get back to them, yes.
All right. Well, thank you so much for bringing up this topic. This is something that I think everybody is interested in right now, and it's definitely going to be evolving. So we want to make sure that people know what the basics are right now.
Thank you, and thank you to all those people out there working in the first responders.
Absolutely. Stay safe. Thanks, everybody, for joining us in Ask the Attorney. Easy for me to say. Have a good night.